breaking news. The cop cover-up trial out of Chicago. As you may recall, these 3 police officers were charged with conspiracy and covering up the shooting by Van Dyke of McDonald to say that it was a reasonable force. Now, you know that Van Dyke has been convicted of killing McDonald. So it's interesting that this verdict read by this judge after writing a very long opinion and reading it out loud, not guilty on all counts. Let's listen again to her concluding sentences of her order.
This court has found that the state did not prove beyond a reasonable doubt that there was an agreement between any of these defendants or others or any act in furtherance of the agreement. As such, the court finds there was no conspiracy and all the emails are therefore irrelevant. Conclusion. The crux of this case rises and falls on whether the information that the officers, including March, put in their reports or told the March was false, and if so, was it done to prevent Van Dyke from further investigation or prosecution? For the reasons stated above, this court finds that the state has failed to meet its burden on all charges. Therefore, there is a finding of not guilty as to every count and each defendant of conspiracy, official misconduct, and obstruction of justice.
Let me just say that. What about the professionalism of those attorneys and defendants? Listen to that news they just heard. Not guilty on all counts, life in the balance, and they all just kind of sat back and I think took a deep breath. On that, Ross Kramer, our attorney before, did have to go, but we have our next legal analyst expert. Very happy to introduce Don Papcsy, criminal defense attorney. Thank you for being here today.
Thanks for having me.
All right, so let's talk about this. First of all, she read for a very long time. So this order, I'm sure, is going to be 20, 30 pages. In a criminal trial, in your experience, is it unusual to have such a lengthy order?
It is. I mean, usually you want to make the orders less. They make it a little less so that there's less to appeal later on. That way the judges can sort of hedge their bets, so to speak. I was surprised by this verdict. I actually saw it maybe going the other way, but I guess they bought into the defense's arguments, and that's what you get.
All right. So listen, part of what I liked, and I think that we all know when a judge makes a decision, they have to apply the facts to the law. She was very thorough in doing that. And she went through the evidence in 4 different pieces of evidence that she specifically had findings about. 1 were the police reports that she looked at. Number 2 were the videos. Number 3 were the victim's actions, so how he acted before he was shot, meaning Laquan McDonald. And then number 4, all of the emails. And that, she said, look, speculation at best as to conspiracy, looking at the emails. So she looked at all of this evidence, and I felt like she was saying, I don't even see that there are any consistent attempts to cover up or communicate. Witnesses were interviewed, information was put in reports, and she really, I think, absolved all 3 of these defendants of any and all responsibility, not just by saying not guilty, but by saying, listen, I just don't think the evidence was there.
You love when judges do that. You want judges to be active and really break things down for you as a criminal defense or a prosecutor, both lawyers, both sides. I think they really bought into the consensus is not conspiracy. Just because you have a consensus about what happens doesn't mean that everybody conspired for that to be the actual story that they wrote down. And I think that was one of the defense lawyers, hit on that over and over again. Another one said, don't criminalize opinions. When we start saying, that you're going to, just because one person has an opinion, another person has the same opinion, especially for one of the police officers, then you're starting to put police officers in a position where if they have opinions that just happen to be the same opinion on something, it turns out to be wrong because maybe a video where you slow it down, one of them made the example of like a ref in a game where they'd be able to slow things down for instant replay, and then it turns out, on the field they call it one way, but then they call it different when they get to slow it down in front of the jury, in front of the judge many, many times. You might come up with a different conclusion. They didn't have that chance. They were acting as it happened, and then soon afterwards writing the reports, and you would come up with a similar conclusion.
Right. So really just an amazing outcome. So let's talk too about now, what are the next steps? These 3 are free, and we just had a previous guest who said, listen, that opinion might be used by Van Dyke when he appeals his conviction for the murder of Laquan McDonald. Do you agree that this opinion could be used for that effort?
I actually don't agree with that. Okay. I think that his trial was very different in the sense it was based on what his actual actions were being on the scene. He was on the scene for a very short period of time. It was like 30 seconds. He started firing his weapon, I think 6 seconds after he exited his vehicle. I don't know if they'd be able to actually use that on appeal for his trial under the standards of appeal. I don't think that would be something that would be appropriate, let's say. But you never know, right?
Right, absolutely. All right, so what we're going to do now is we are going to regroup after, I'm all flustered just because I don't know that everyone expected a not guilty verdict on all 3 counts. But having said that, or all 2 counts, 3 defendants, we are now going to switch gears again and return to the California case versus Charles Merritt. He goes by Chase. This is the one in which he is accused of murdering 4 family members, a 3-year-old, a 4-year-old, the mother and the father, over a business relationship with the father. And the bodies were found in a desert by a motorcycle rider who actually hit one of the body bones, and then they discovered all of these bodies. We have an excellent summary now we want to show you of the Merritt case and the facts behind it.
Charles Merritt is facing murder charges for allegedly killing a family of 4 and burying their bodies in the desert. From their Southern California home on February 4th, 2010. Police found no evidence of struggle or foul play, but did identify signs that the family left in a hurry. The family car was found 4 days later abandoned at the Mexican border with no sign of the McStays. Law enforcement eventually believed the family fled to Mexico. Surveillance video at the border showed a family of 4 resembling the McStays crossing the border on foot. Officers also found search history on the family computer about travel to Mexico and passports for children. But a grisly discovery came nearly 4 years later when an off-road motorcyclist discovered the partial remains of a child's skull on the outskirts of the Mojave Desert. A search revealed 2 shallow graves containing the remains of 3 more bodies. DNA and dental records matched the bodies to that of the McStay family. A 3-pound sledgehammer was buried with the bodies. The family had been bludgeoned to death, according to prosecutors. As law enforcement was investigating the McStay's family disappearance, San Diego detectives interviewed Charles Merritt, a business partner of Joseph McStay. According to the affidavit, it was determined that Merritt was the last person to see and talk to Joseph alive. The 2 had met at a fast food restaurant before the family went missing. The last cell phone activity on Joseph's phone was a call to Charles Merritt. Merritt's DNA was also found on the family car abandoned at the border on the steering wheel, the gear shift, and the radio. He claimed he never driven the car, but rode in the passenger seat with Joseph 6 weeks prior to when the family went missing. Charles Merritt is pleading not guilty to the charges. Defense attorneys are pointing to another business associate as a possible suspect. Merritt is facing 4 counts of murder. For Law and Crime, I'm Rachel Stockman.
Thank you, Rachel, for that excellent summary. One of the things you're going to note is, again, this happened in 2010, the family disappeared, and then here we are in 2019, so 9 years, and that's 9 years without a specific crime scene. Now, the prosecution alleges that this did happen in the home, but for the first 3 years, law enforcement said they thought this family voluntarily went across the border to Mexico. So there's a lot of circumstantial evidence, and there's a long time frame that the prosecution is going to have to deal with. Now, our own Kathy Russin, we love having her there live because she actually went to the Mojave Desert where this burial site is located. Let's listen to her special report.
We are currently at the site where the remains of that family of 4 was found at the end of 2013, nearly 3.5 years after the family went missing. A motorcyclist came across the skull here, and investigators eventually found 2 shallow graves with the remains of the family. Now, this location is just north of Victorville, California, in San Bernardino County. Prosecutors say Charles Merritt killed the McStay family in their home in San Diego County and eventually drove the bodies here and buried them. It was a 3-pound sledgehammer. The cause of death is said to be blunt force trauma to the heads of this family of 4. The prosecutors in their opening statements say that Charles Merritt drove them here and that you can see a set of tire tracks. Now, it's very hard to see them now because so much time has gone by. I can actually see a little bit of them, but they were very clear, but even back 3.5 years after the family went missing. There's another set of tire tracks about 20 feet over. There are 2 actual grave sites. This is a memorial that the family put up, but just to the bottom of this is where the first grave was. The second one was about 20 to 25 feet over there. Now, the defense in their opening statements say that more evidence points to a third business partner, Dan Kavanaugh. They also say that evidence here at this scene show that there were more than one person that committed this. They told jurors they will see the 2 sets of tire tracks and they will see that they're not consistent with the same vehicle. They also put the theory up that Joseph McStay was killed, brought here, and that Summer and the boys were brought here alive and then killed here. They say that the family was not killed at their home. There is no evidence of any blood or any DNA found at the home to show the family was killed there. The trial is expected to last up to 6 months, and Charles Merritt will face the possibility of the death sentence if he's convicted. I'm Kathy Russin for Law and Crime.
Thank you, Kathy. So needless to say, any type of crime, murder, especially egregious when you have an entire family of 4. So certainly seeing those graves, can only imagine how the families of those victims must feel at that great loss. Now, let's talk a little bit, Dawn, about the evidence. And here's what I want to talk to you about. This is really a case in which you have extreme different theories. And so the prosecution has said that in their opening statements, this family was murdered in the family home. Defense says, nope, not murdered in the family home. In fact, we think that one of these defendants, family members, was specifically murdered here. And when you get to the actual site with the graves, the prosecution says, oh, yep, it was this defendant who was here. And then the defense says we've got 2 different sets of tire tracks, one of which is a car similar to the defendant. He didn't do it. And in fact, there's going to be evidence that somebody else was there and somebody else committed this crime. How do you, I mean, those are really extreme opposite theories of the case by prosecution and defense. How do you reconcile those?
You don't. I'm not a big fan of these types of cases. In our state, we had the Michael Skakel trial, the Greenwich-Moxley murders, and 40 years had gone by between the murders. This was only 3 years, but then years after when the actual charges came in. And when you have, that period of time, it's very hard to start to try to get evidence that's not perishable. So you have tire tracks. You have one set. They think it might match the type of vehicle. They're not saying it was the exact set of tires or anything like that. It's 3 years later. They say something happened at the house, but there's no DNA, I believe, at the house linking anything to Mr. Merritt. They say, well, there's some DNA inside the car. He says, of course I drove in the car. I knew him. I've been in the car. I was never on that side of the car as far as I remember, but that doesn't prove anything. The more time that goes by, it becomes more and more circumstantial. As a defense lawyer, I've never been a big fan of the kind of cases that are just based purely and mostly on circumstantial evidence.
What about a case like this when you have the circumstantial evidence and then the state, quite frankly, is already introducing evidence of motive? They are saying the financial motive, that Merritt was a business partner and had a gambling problem, and that's why his motive was to kill this family. Does that add anything to you in terms of a stronger case for the prosecution or not?
What we always try to talk to juries about is that motive is an actual element of any kind of crime. But it is important, and we all know that juries do take that into consideration. In this particular case, you have Mr. Kavanaugh. Maybe had more of a motive, and there were conversations between him and Mr. McStay that were much more damning than they would be for Mr. Merritt, which should be introduced. Some of that I know is going to be introduced, or at least some of the interactions between Mr. Kavanaugh and Mr. McStay. And then you also have the fact that the type of crime. Why would he kill the entire family? There was also evidence that there might have been a rape involved with the mom. If it was about financials and he just wanted to do away with Mr. McStay because he didn't want to have to owe, it was only, I think, $40,000 or something like that. Would you kill the entire family and rape one of the people? It's not consistent, and I wouldn't be surprised to hear expert testimony as to that type of psychology behind that too.
Right, that's one of the things I know we've talked about. And so we are going to return now to some of the testimony that was pre-recorded from yesterday afternoon. And this is the judge asking questions of Detective DeGaulle that was on the stand in this case.
When you were talking about the policy for in 2010 on a missing person report. Missing persons report is taken. It goes to the missing persons division or unit.
Actually, it goes to an area detective. Area detective is a lower level of detective that does property crimes, station crimes.
Okay. And then that area detective has 10 days to see if he can basically figure out what's going on. Can he locate the family, figure out where they might be? If he comes up with nothing after 10 days, then he refers it to homicide.
That's correct.
He or she.
That's correct.
So in this case, let's assume for the moment that after Deputy Tingley was there on the 15th, and he clears the house. He says, okay, there's nobody in the house. There's no deceased people, no injured people, no sick people, no sleeping people, no one just hanging out in the bedroom, hiding down watching TV, no unauthorized people, no evidence of forced entry, no evidence of violence or struggle or blood or anyone being injured in the house. He says, okay, they're not in the house. It's a missing person. I'm going to turn it over to the area detective. Okay?
You're saying hypothetically?
Yeah, let's assume he did that.
Yes.
And he turns it over to the area detective with that information, saying, my information is they have not been seen for at least 10 days.
Okay.
Okay. Would that area detective then still have 10 days to follow up and check, or would he or she immediately turn it over to homicide because they've already been missing for 10 days?
In my experience, that case is going to come right to me right away.
All right, again, so that's testimony that was presented yesterday, and the judge was asking questions. So let me ask you that, Don, we were just talking about it. Do you typically see judges start asking questions of witnesses? I know we have the ability, the discretion, but is it typical in your experience?
It's not typical when you have experienced criminal defense lawyers. A lot of times when the criminal defense lawyers, the only time if they're not asking questions that the judge wants to hear answers from or thinks that would benefit the jury, a judge will step in and sort of pick up the slack, so to speak. It's not something you want to see as a criminal defense lawyer or a prosecutor. You really don't want a judge to be stepping in and asking questions of your witnesses. You should be able to control your part of the courtroom.
So to be honest, that can happen for prosecutors as well. If they're not effective in asking their questions or leaving gaps, then they can, the judge can do the same thing, right? If it's the prosecution.
Yes, and it's a little embarrassing, I would imagine. I haven't had it happen to me too many times. I mean, I've had judges that, that's their style because they want to do that, and so they do it to everybody, so I don't feel bad. But if it happened in most places, I would feel like I was, not doing what I was supposed to be doing.
Right, and I will say from watching, this has been a really active judge. He's had to rule on a lot of objections, a lot of things have come up, and he does a lot of sidebars. We are going to take a short break. We continue to cover trials live today, covering multiple trials, so please come right back. All right, welcome back to Law and Crime. Just to give you an update, the McStay family murder trial, and that's California versus Charles Merritt, is on a break. We are recapping some of what happened yesterday. One of the things I was just talking with my special guest about is the evidence and from the different crime scenes, and arguably there's no crime scene in this particular case. Now, the prosecution alleged in opening that the crime scene was the house, the family house where the four lived. And remember, they disappeared back in 2010. So we're going to listen to some more testimony of Detective DeGaulle, who testifies about some splatter on a table in the home. Let's listen.
Your career as a police detective seen blood spatter.
I have.
So what you see in the bottom part of this photograph, you can't say it's blood, right?
I can't say it's blood. It's a horrible moment where I don't know what it is. I did not see it with my naked eyes when I was in the residence at all. And now that this attorney zoomed it in, it puts a pit in my stomach, but I don't know what it is. I can't say it's blood, and I can't say it isn't blood.
Does blood dry in a specific pattern?
It does.
How does it dry?
No foundation.
Sustained with foundation.
You see training as to how blood spatter or blood will dry?
I went to a 40-hour course by the San Bernardino Sheriff's Department for blood pattern analysis.
Does blood dry in a specific manner?
Yes.
How?
It traditionally obviously dries at where it's the thinnest on an object. If it's blood that's spattered onto an object, the outside or the thinnest edges are going to dry first, and then the thicker or the raised area is going to dry later. And in this, what you see is skeletonized. We call it skeletonized drop of something.
Well, more than one drop.
A lot of drops.
You said you didn't see it with the naked eye.
No.
And there are reasons for that, right?
Yes, I don't like to make excuses, but there are reasons.
What are some of them?
The reasons for not seeing this with the naked eye, what you're seeing even in this photo where it's not zoomed in, you're seeing the table, and it is highly illuminated right here. There's a reason for that illumination, and it's called a flash. And a flash is obviously it's a camera flash. Our digital camera has a not so modern flash, just illuminates the table really bright. Because of that bright light source, it's much easier to see dirt and whatever that is, where the naked eye could be sitting right there. We actually worked on this table, and I'm not talking just Detective Troy DeGale. I'm talking, I was one of the ones who worked at that table, but our whole team, and I had like 10 people searching with us, and we looked at baseboards, ceilings, walls, floors, behind toilets, lift the toilet lid. That's the way we searched. Several of us sat at this table, and that was not seen because of, I'm going to go with light source, the naked eye, it's very close to the same color as a table, very small, and not.
So Detective Dougal admits it leaves the pit of my stomach because I can't say if it was blood or not. We didn't notice it really. So now let's hear, what does the forensic evidence tech have to say? She testified about the same marks on that table last night. Let's listen.
When it was zoomed in?
Yes.
And were you asked what you thought it was?
Yes.
What was your reaction when you were shown that?
Objection, relevance, and speculation. She's going to say what it is.
Overruled. Well, my answer is more on what it could be. Does that make sense?
Actually, my first question was, what was your reaction when you saw that?
When I saw it, I was horrified.
Why?
Because I thought it was something I missed. And horrified me to think that I would miss that.
You don't recall seeing that day?
I know I didn't see that day.
Okay. Based on your experience of processing crime scenes, did you have a belief of what it could be?
Objection,
Yes.
calls for speculation.
Overruled.
And what was that?
I thought it could be blood.
Why?
Based on my experience with the color and the patterning of blood stains and blood spatter, it looked to me like it could very well be blood.
Was there something about the area in which I zoomed in on with these particular spots that specifically, based on your training experience, were significant?
Yes, I thought so.
What?
I'm not a blood spatter examiner. That takes tons more training than I have. But I have had classes in blood spatter, and to me, it looked like...
I'm going to object as the foundation. If she is not an expert, doesn't investigate.
Have you seen blood spatter previously, though, in investigations?
Yes.
Have you documented it?
Yes.
Have you tested it?
Yes.
With, was it a hemastick?
No, we use swab and Castlemeyer usually.
Okay. And so you have experience looking at items.
So now we have Dennis Williams, and again, she's the forensic evidence tech who says, I know I didn't see it that day, and then saw it after and says she thought it could be blood. Now, how do you handle this testimony, Donna, as a criminal defense attorney when they flat missed it? Let's be honest.
I love it as a criminal defense attorney. It's maybe the greatest testimony that I've ever heard, seen on television. It's your forensics person who's supposed to do a thorough analysis of the scene says, I just didn't miss it. It's right there on the table. It's actually literally sitting right on the table, what would be maybe blood splatter. And this is years ago, and now she's looking at it saying, oh, I'm horrified. And she doesn't even say it's definitely blood splatter and I missed it. She says it could be. I mean, those could be, should be's are meant for great cross-examined material.
All right, so 18, 19 years ago when this happened and they went into this house, and I think they may have assumed that the family was missing, but didn't really fully realize that it was a crime scene. Do you think now it's handled differently? Do you think if a family's reported differently, how law enforcement responds is handled more aggressively than it might have been in 2000?
I mean, there's a possibility. At that point, you had already been through some pretty big trials. I think we remember one big one in the 90s that had a lot of forensics things going on. A man called Dr. Lee was testifying in that trial. So I think after that time period, everything in forensics became a big deal. So I would hope people be doing a better job.
All right. So I am signing myself off. It's been a great afternoon with all of you viewers here today. I'm Ashley Wilcott. And next it is Daily Debrief with Aaron Keller. We look forward to hearing a summary of what's been going on and all his insights and expertise on the cases. So we will be joining next day once it's back. It is on a break, and we're covering lots of live trials on Law and Crime. Please come back.